What is making the difference between a J1 waiver that gets approved versus one that does not? Today we're going to highlight and go into depth on some recent case studies where we got approvals in 2024 for J1 exceptional hardship waivers. So you'll want to stay tuned to learn what works. Hi, my name is Coach Ranchod. I'm an immigration attorney that's been practicing for over 22 years. And let's get started. Now, when you file for a J1 hardship waiver, it's important to note you must have a qualifying relative in order to qualify. So that means either having a U.S. citizen spouse, lawful permanent resident spouse, or a U.S. citizen child or lawful permanent resident child. U.S. citizen parent does not qualify for a J1 exceptional hardship waiver. Now, please note that this is specific to a J1 exceptional hardship waiver case, not other types of waivers. This was a very difficult case to get approved because it involved Fulbright funding. Here our client was from Russia. Let's look at the processing times. We filed with USCIS and Department of State on April 11th, 2022. Department of State processed the case on April 25th, 2022. And then Department of State processed the I-613 on February 21st, 2023. Department of State issued a favorable recommendation on January 18th, 2024. And finally, we got an approval on February 6, 2024. So again, here this case was approved in a little less than 2 years. And we were very happy that it got approved, especially since this case involved Fulbright funding. Now let's look at what arguments we made to get the case approved. First, we talked about the exceptional hardships that would be there if the spouse had to leave and go to Russia. We explained that the J1 spouse mental health is dependent on the J1's presence, and her employment in the US is critical because she's the sole provider. Not only that, but the spouse needed access to high quality mental health treatment provided by the J1's employer's insurance coverage, and unfortunately that would not be available in Russia. Here there was also financial hardship that the J1 holder would struggle to support their necessities in Russia if they were going to move to Russia. Not only that we also argued that the safety of the US citizen spouse would be an issue as well. And we also highlighted the value of J1's work to the US as she's an accomplished researcher, author, and top-tier higher education instructor. By allowing the J1 to remain in the US, that would ensure that her contributions would continue to benefit our country, and her American spouse can receive the required support and care. I'm very happy that this case was approved. Every case is tailored to what the client's unique situation is. Everyone has a unique story, and it's really important. And that's what we do in our legal brief. I want to thank you for taking the time to watch this video. By watching this video, you're bettering yourself. By bettering yourself, you're bettering our country. And by bettering our country, you're bettering the world. Thank you. Bye for now.